This is an application filed by plaintiffs for temporary injunction under Order 39, Rule 1 and 2 of the Code of Civil Procedure for restraining the defendants from causing obstruction and interference into the possession of plaintiff over the house bearing municipal house number 1231 situated at Belapur, Taluka Srirampur, District Ahmednagar. The plaintiff has also prayed for temporary injunction restraining the defendant number 1 from alienating the said house para. The case of plaintiff in short is as under para. The plaintiff submitted that her father Gopal died in the year 1990 while her mother Radha died in the year 1985. Her father was freedom fighter and therefore the government had allotted land survey number 326 at measuring 5 acre to Gopal. The suit house bearing new house number 25 and old house number 211 situates in this land. The said land survey number 326 was wrongly mutated in the name of defendant number 1. The plaintiff submitted that the defendant number 1, who is her elder real brother, and defendant number 2 jointly sold land survey number 326 to many persons. The plaintiff further submitted that the oral partition took place between plaintiff and defendants before 20 years ago and the suit house was allotted to the plaintiff. The plaintiff is residing in the suit house since long back. However, the defendant number 1 is intending to alienate the suit property to the defendant number 3 by depriving the rights of plaintiff. He is also causing obstruction to the possession of plaintiff over the suit house. Therefore, she has filed present application for temporary injunction. Para. The suit summons is duly served. The defendants number 2 and 3 failed to appear. Therefore, suit proceeded ex parte against them. Defendant number 1 has filed his written statement and say at exhibit 27 para. The case of defendant number 1 is as under. The defendant number 1 has denied the relationship with the plaintiff. He has denied that the Radha was mother of plaintiff and also denied that Gopal was father of the plaintiff. He submitted that he himself is the owner and possessor of the suit house and the plaintiff is neither owner nor possessor of the suit house. He submitted that defendant number 2 is his sister and they have inherited the land survey number 308 and 326 situated at Belapur after demise of their father Gopal. Therefore, the plaintiff has no right or concern with the suit house. They submitted that in RCS number 72 oblique 1982, the decree was passed and on the basis of that decree, defendant number 2 became owner of 3 acre 24R land in survey number 326. Thereafter, a large portion of this property was sold by defendant number 2. One RCS number 112 oblique 1992 was filed by defendant number 1 against defendant number 2 and on the basis of compromise decree passed in that suit, the defendant number 1 has become the owner of the suit house. The defendant number 1 has denied the contention of the plaintiff that there was the oral partition and suit house was allotted to the plaintiff. Therefore, on perusal of entire written statement, it is seen that defendant number 1 has totally denied the contentions of the plaintiff. Para. I heard the learned advocate for both the parties. Considering the rival pleading and documents produced on record, following points arises for my determination, and I have recorded my findings thereon with reasons as under. Para. In order to prove prima facie case in her favor, the plaintiff has produced on record the assessment extract of the suit house, 712 extract of land gut number 326. She has also produced a copy of Aadhaar card. She has filed the affidavit of one Kamalbai at exhibit 31. Para. The defendant number 1 has produced on record the various documents below exhibit 33. These are tax paid receipts. He has also produced on record certified copies of decree passed in RCS number 112 1992 and also affidavit of witnesses Akash, Prakash and Dinesh at exhibit 37 to 39 respectively. Para. The decree in RCS number 112 1992 also shows the ownership of defendant number 1. Though the plaintiff has pleaded that she has paid the municipal taxes, yet the tax paid receipts have been produced by defendant number 1, which shows that the taxes have been paid by defendant number 1. The plaintiff has relied upon the affidavit of one Kamalbai. However, it is seen that she does not reside at Belapur. Likewise, her affidavit will not override the basic documents pertaining the ownership of the suit property. In these circumstances, it is prima facie seen that the plaintiff is not in possession of the suit house. It is also prima facie seen that the plaintiff has no interest in the suit house. Therefore, I come to the conclusion that the plaintiff has failed to prove the prima facie case in her favor. Therefore, the question of balance of convenience and irreparable loss will not arise. Hence, I answer points number 1 to 3 in the negative.